everyone. A very good evening to all of you and welcome to the live virtual classes of Board of Studies of ICAI. This is the CA intermediate course and we are dealing with the paper on corporate and other laws. And the topic which we are discussing is on General Clauses Act 1897. And in fact, it is a set of 4 lectures we will be having on General Clauses Act and interpretation of statutes. So first we will begin with the General Clauses Act 1897 in 2 sessions, that is today and tomorrow. And then on Monday, we are going to have the interpretation of statutes followed by another lecture to close this session. Our objective here is to understand the nuances of interpretation and how interpretation works in courts of law. And as I have always been saying that the chartered accountants are in a way performing also the job of a lawyer because they have to interpret the provisions, they have to work on the financials, papers, wherein there is a lot of interpretation involved. And you have to interpret the provision for the benefit of your client in line with the laws which are laid down. So most of the cases, it will be like taxation laws or it will be customs law or for that particular matter, any other laws which relates to finances of a company and interpretation of that. These tools will become handy. So basically you need to understand how these different laws operate, what are the premises in which it operates, and what are the interpretation clauses, what are the interpretation mechanism by which the court interprets the law. This becomes very handy for you when you are doing your practice. As well as from the examination perspective, these 2 topics, I think there are 2 or 3, 4 questions which comes in it, and it will be useful for you to brush up these topics to get marks into these areas. To begin with, let me give you a brief background of this. So in terms of the learning outcomes, if you look at your course material, the learning outcomes says that at the end of this chapter, you should be able to explain the purpose of General Clauses Act, that what is the objective of General Clauses Act. Then you should be, having some basic understanding of the legislation, how it is arranged, and then know the general definitions under the law. There are a couple of definitions which we will be seeing, and these definitions applies across the different central legislations which we will have a look at. And then you should be able to identify the general rules of construction as given under the General Clauses Act, and then explain powers as to orders, rules, etc. made under the enactment, and then gain knowledge of other miscellaneous provisions. So as you can see in the picture, this is the picture of a Bear Act. So the name of the law is the General Clauses Act 1897. As you would note that this is a pre-independence era legislation, but it still holds good in the country. And it is getting applied by the courts in different interpretation situations. And then you also see here incorporating the Jammu and Kashmir Reorganization Act 2019. So previously, this law was not applicable to Jammu and Kashmir, but after the abrogation of Article 370, the law has now been made applicable to Jammu and Kashmir as well. So it applies to the whole of India. And that is why you will see that Section 2 of the General Clauses Act has now been repealed after this amendment. However, what is important to notice here is that in, now at the bottom, you can see with state amendments. So General Clauses Act, central government laws, it applies to central government laws. But with reference to the state government laws, there are state government General Clauses Act. So we will touch upon this topic in a while in more detail. So this is the overall premise of the General Clauses Act. And if you look at the law, it is arranged into 6 major parts. So first part talks about preliminary, that is Section 1, which includes the commencement, the name, and the Section 2, as I have already told you, is already repealed. Then there is general definitions. So general definitions is given in Section 3 to 4A. And there are a set of definitions we are going to see one by one. Then general rules of construction are provided in Section 5 to Section 13. Like, for example, one of the rules which relates to is rule of repeal. So what happens when a law gets repealed or a part of a law get repealed? So whether it can continue to interpret, whether we can continue to look at that particular law, or we substitute with new law, all these provisions are getting covered under the general rules of construction. Then we have powers and functionaries. So this actually governs the different offices of the central government and how the central government offices are arranged. And then we have provisions with reference to orders, rules made under the enactments, that is section 20 to 24, and then miscellaneous provisions under section 25 to 30. So we intend to look at the initial sections till I think section 8 we will cover today, 8 or 9, and then we will move ahead with the remaining ones in our next session. Today's session's objective would be that you understand the architecture of a legislation, how the legislation needs to be read and interpreted together. All these things today we are going to cover. If you have a snapshot of the law, it is arranged like this. I have given you a brief of the 6 sections which you saw. So you can see here very much. So short title, preliminary, it talks about short title. And then we have general definitions, which applies to all situations. And then there is a specifically an application of foregoing definition to previous enactments. And then there is a application to general Indian laws. And then you can see general rules of construction, section 5, 6, 7, 8, 9, 10. So, and 11, 12, 13. So these are different situations in which the rules of constructions are mentioned. We will go through each of these sections one by one. And then powers and functions, you can see section 14 to 19. So this talks about basically the powers which can be exercised by the various government offices. What happens when the office becomes vacant or the new person comes, whether he takes away the previous thing or not. That these are the things which are covered in powers and functions. And then there is provision as to orders, rules, etc. under section 20 to 24, and then miscellaneous provisions. Now, if we move further and talk about the objects and reasons of General Clauses Act as to why this law is there, and you would notice that one of our objectives of having this lecture today is to understand the objects and reasons of General Clauses Act. So if you have a look at that in a way, so it will you will come to know that why this law is in existence. I see the chat box and someone has written the voice is overlapping. Is it now fine? All of you are able to hear me clearly. I hope it is clear to you all. Can you just, okay, great. Thank you. Thank you for your input, Vishaka. Let me now take you to this objects and reasons of General Clauses Act. So if we are talking about objects and reasons of General Clauses Act, as you would know, that it is a pre-independence legislation, but still it is existing and there is a need for it. So what is the need for it? What are the objectives? So if you see in the in a report which has been given by the Law Commission of India, that is 183rd report of the Law Commission of India, it says interpretation statutes such as General Clauses Acts are enactments intended to set standards in construction of statutes. So when I say standards in construction of statutes, means some parameter, some norm it establishes for the interpretation of the statutes. So here the expression construction is of seminal importance as it is oriented towards enabling a seeker of the text of a statute to understand the true meaning of the words and their intendment. So see, this is beauty of law, that it many a times the law does not give you the plain meaning as you would read it and it is just giving you the meaning automatically. It doesn't happen. You have to read the law and try to make sense out of the law, because law is not made as per a specific factual situation, right? So the law is generally made. And whenever you will be, faced with a fact, you have to look at the specific fact and then the law and apply the law. So this particular task is referred to as construction. So every situation you would require a interpretation, you would require a construction exercise wherein you are fitting in your facts of the situation into the law and try to either get benefit of it, or if there are authorities, they would like to get benefit. Like let us take an example of taxation of a statutes. Okay. So tax provisions say that tax can be imposed on X situation. Okay. It is written there. Now, what is this X situation is matter of construction. So the taxation authorities would always try to interpret X in their favor, and the clients would always try to interpret this X in their favor. And that is where, if there is a conflict, if there is no harmony in these interpretations, people go to court, and then court interprets them for that, and they tell them that yes, in these situations, the law needs to be interpreted like that. I hope you have got the reason, one of the reason of this. Now, apart from setting coherent and consistent method of understanding enactments, the interpretation statutes also subserve the purpose of reducing prolixity of legislations. Prolixity, when I say prolixity refers to the word that many of them. So you don't repeat the things again and again and again. So if you don't have General Clauses Act, say for example, all these 30 provisions which you found in the General Clauses Act has to be repeated in each central legislation, right? So this actually avoids repetition of these provisions again and again into the different central legislation, and hence the interpretation statutes are made. Now, the standard principle formulated in the interpretation of statutes must therefore be read into any and every enactment falling for consideration. So in ultimate analysis, interpretation statutes or definition in interpretation clauses are only internal aids of construction of a statute. So there are two kinds of aids of construction, and this we will see in interpretation class. One is called internal aids to construction, which basically means that you find the support in interpreting the legislation from the legislation itself. Like say, for example, you are interpreting Contract Act. Whatever you are referring to in the Contract Act will be referred to as internal aids of construction. Either it may be its preamble, it may be its clauses, heading, etc. Now, external aid is something which is beyond the act. Like, for example, you are referring to a report or maybe a constitutional assembly debate. All these things will be referred to as external aid to construction. We will read them in detail when we see the interpretation of a statutes session. Now, the question is, who do they aid? So these interpretation or construction statutes are aiding whom or helping whom? So interpretation is basically the exclusive domain of the court, and hence it helps the court in interpretation of statutes. So can, a general layman can utilize General Clauses Act to interpret? Probably not, right? So it is the job of the court. But yes, as a CA, as a lawyer, we always try to, look at those provisions and interpret or bring an argument to the court that yes, this should be interpreted in our favor, right? So that is how these are presented. So this is what was also held in one of the cases, that is Pernod Ricard versus the state of Madhya Pradesh. That this is a 2024 case. And you can see here 2024 INSC is a neutral citation, INSC. So Indian Supreme Court, and 327 is the case number, or you can say page number, case number. So this is how nowadays you will find the neutral citations, and you can easily find the case. So this citation helps you finding the case law. I hope by this time you are clear of the objects and reasons. I will spend one more slide on this to make you understand. But before that, I referred to the, State General Clauses Act. So the General Clauses Act applies to the all central legislations, and it may also apply to state legislations unless there is a specific state legislation with reference to general clauses. So there are many states which have come up with their own General Clauses Act, and this applies to all the state legislations. Like, for example, if there is a Maharashtra Land Revenue Code, so that will apply in Maharashtra. Say Stamp Duty Act of Maharashtra. So if you have to refer to those, then you have to refer to Maharashtra General Clauses Act. Likewise, you have General Clauses Act in Bengal, you have the General Clauses Act in Punjab, Karnataka, Kerala. So these are different General Clauses Act in different states. So But as far as CAs are concerned, I think mostly they are dealing with central legislation. So General Clauses Act applies. But in certain situations, if matter relates to stamp duty, matter relates to land, then in that situation or property for that matter, the State General Clauses Act may also be applicable. But for your syllabus, you don't have to concentrate on State General Clauses Act. You have to only refer to the General Clauses Act, the central one. If you see the objects and reasons of the General Clauses Act, the statement of objects and reasons also provide the objects and reasons for General Clauses Act, and it clearly lays down 4 or 5 points. The first point is to shorten the language of central acts. This I have already told you that the General Clauses Act provisions helps remove the repetitions. So if, say, for example, General Clauses Act would not have been there, then what would have been the situation? The situation would have been that all those 30 provisions would have to be repeated again and again in all central legislation. So it shortens the language of the Central Act. Second is it provides as far as possible for uniformity of expression in Central Acts by giving definitions for a series of terms in common use. So it gives you the common definitions of different words, which you can utilize again and again for different situations. Then to state explicitly certain convenient rules for the construction and interpretation of central acts. So as you saw, section 5 to 13, it gives certain rules, and these rules of constructions apply across the board. Like, for example, how do you calculate time and distance? How do you calculate, what do you mean by gender? Which one you will take? Like that. So these are the things which will be taken into consideration when you are interpreting through the General Clauses Act. And then it also guards against slips and oversights by importing into every act certain common form clauses, which otherwise ought to be inserted in several central acts. So this is what I have already told you before. So many a time, say, for example, you want to repeat all the clauses in all central legislations. It may happen that in one of the legislation it gets slips, or by oversight it is not there. So these things can get prevented when you have General Clauses Act. In the case of Chief Inspector of Mines versus Lala Karamchand Thapar, in 1961, Supreme Court, while interpreting one of the provisions, said specifically that the purpose of this act is to place one single statute, different provisions as regards the interpretation of words and legal principles, which would otherwise have to be specified separately in many different acts and regulations. The purpose of the act is to avoid superfluity of language in statutes wherever it is possible to do so. So whatever the General Clauses Act says, whether as regards to the meaning of words or as regards legal principles, has to be read in every statute to which it applies, right? So this is what the Supreme Court has said as far as General Clauses Act's scope is concerned. Now let us look at one example of interpretation as to how interpretation works, though this example is not of, it's not of General Clauses Act, but just to understand how interpretation works and how the courts lend to different legislations to understand, right? So this is a very important aspect. There is a question, and it says whether reducing prolixity means the law understandable. Prolixity does not mean law understandable. Prolixity actually means that too many things. So General Clauses Act, helps you avoid too many things in the legislations again and again. That is what it means, prolixity of terms. Okay. Now let us look at this example. So in this example relates to SURFACE law. And if you see, this talks about appointment of advocate to take possession of secured assets. I don't know how many of you have studied SURFACE law. SURFACE Act is an act which allows the banks to recover loans. So say, for example, if a bank has given you a loan and there is an NPA in that loan, then bank can seize your assets under section 13 of the SURFACE Act. And law also provides for certain powers given to the chief metropolitan magistrate or district magistrate, CMM or district magistrate, to take the possession of the secured assets and documents relating to the secured creditor. Now, here the question was that can CMM or the district magistrate, uh, you know, allow the advocate to be the advocate commissioner to take this particular position, or he has to do himself or herself. Now, in this situation, the matter went, and in this case, the DM would have appointed an advocate as an advocate commissioner to do the work on his behalf. This particular fact was challenged before the court. And the court looked at the question of subordination, and it said that there are few kinds of subordination, that is administrative subordination, statutory subordination, and functional subordination. So when you say administrative subordination, this is kind of a situation like, okay, fine, district magistrate is not there, then he will delegate someone in his office that, okay, fine, you do this particular job. Or if you say statutory subordination, the statute itself says that, okay, fine, if SP is not there, DYSP can do the work. So, but functional subordination is something which was applied in this case, wherein the court said that, okay, fine, the district magistrate or chief metropolitan magistrate may not be available always. And say, for example, if he has to do hundreds of this seizure, he cannot do it himself. And hence, he need to have someone on his behalf. And it was interpreted as functional subordination. And they said under Section 14(1)(a) of this SARFAC Act, the advocate, if he is appointed, he will be regarded as an officer of the court and subordinate to CMM, DM for the purpose of Section 14(1)(a). So this is how the court interprets the law. This is the case of NKGSB Cooperative Bank versus Subir Chakravarti. So you can see how the courts have made a harmonious construction or interpretation in this exercise. Now, there is no General Clauses Act applicable here. It is just to give you an understanding how the courts do the interpretation to find out meaning out of the words and situations which are questioned by people are answered accordingly. So you can see many a times there is a requirement of a functional approach, and this functional approach is also known as purposive interpretation. We will see in interpretation, you will come to know about these terms more. Now, I would like to touch upon a very important article from the Constitution of India, and that is Article 13 of the Constitution of India. Now, if you have read Article 13, you would know, but if in case you have not read, Article 13 goes like this. It says all laws in force. So the term used here is all laws in force. There may be law which are not in force also. They may be on statute book, but they are not in force. I will explain you this in a while. So all laws in force in the territory of India immediately before the commencement of this constitution, insofar as they are inconsistent with the provisions of Part 3, that is Part 3 is the fundamental rights, shall to the extent of such inconsistency be void. So it is saying that there cannot be any law which can be inconsistent with the fundamental rights of the people. So you cannot have law to curtail fundamental rights of the people. And this is a very fundamental thing. And that is how you can see across many legislations are getting challenged before the courts. Why? On the ground of constitutionality. When I say the constitutionality of the law is challenged, that means basically they are going against the fundamental rights of people. If a law is taking away the fundamental right of a person, that law cannot be valid as per the Constitution of India. Article 13(2) says that state shall not make any law. So 13(1) talks about the law which is pre-existing before the Constitution. And Article 13(2) talks about the future making of law. So after independence, the state is not having power to make any law which takes away or abridges the right conferred by this part, that is fundamental rights. And any law made in contravention of this clause shall be void. So you can see any constitutional challenge to a law is done under Article 13(2). So you challenge that. Then Article 13(3) defines law. And it is important for us because when we are talking a General Clauses Act, we are talking about interpretation of law. So definition of law goes like this, and it says in this article, unless the context otherwise requires, the term law includes what? Ordinances, orders, bylaws, rules, regulations, notifications, customs or usages having the force of law in the territory of India. So it is not necessary that law will always be referred to as act. Okay. It may be referred to as ordinance. It may be referred to as orders. It may be bylaws. It may be rules. It may be regulations. It may be even notifications of the government. Many a times the Chartered Accountant of India, ICAI, also issues certain notifications or practice notifications. These are also laws within the meaning of Article 13 of the Constitution of India, because they have got statutory power to regulate the profession, and any notification which comes through that will be considered as law. Then customs or usage having force of law in the territory of India will be referred to as law. Now, what is laws in force? We saw that. So all laws in force we are talking about. Law may be in force, may not be in force. When I am saying laws in force, it includes law which are passed by the legislature or the competent authority and before the commencement of the constitution and not previously repealed. So when I say law in force, that means it has been notified by the government to be in force. So there may be law which are on a statute book, but they are not yet in force. And I can give you an example on this laws in force, and I think I will do it in a while because I think the slide has mismatched a bit. It has gone beyond, so I will explain you in a while. But before that, let us talk about this immovable property. So in this particular, picture, as you are able to see, there is a fish in the hand of the person concerned. What do you think? It is a movable property or immovable property? Okay. Okay, movable property. All of you are saying movable property, the fish which is there in the hand of the person concerned. Interesting. So the person who is having a fish in their hand is a movable property. And what about the rights of fishing in a pond? What is that? That is right to transfer fishing right. So this is a classic case where there is an interpretation as per the General Clauses Act which has happened. So you will see this was a case Anand Behera versus State of Orissa, 1955 case. So here the question was with reference to Section 3 of the Transfer of Property Act, and it did not define the term except to say that immovable property does not include standing timber, growing crops, or grass. A fish do not come under this category. So you cannot define whether it is a property, which kind of a property, movable or immovable. So the General Clauses Act was applied in this case, and they applied Section 3, Subclause 26 of the General Clauses Act, and they read immovable property was defined there, and it said immovable property shall include land, benefits to arise out of land, and things attached to the earth or permanently fastened to anything attached to the earth. So fish is not permanently attached to the earth. Fish is not permanently fastened to anything attached to the earth. Fish is a moving animal, so it is a movable, but it can be taken out. But fish or right of fishing or right to transfer fishing was considered as immovable property because it was interpreted as benefits arising out of the land. So, taking something out of the land or benefits arising out of the land would be called the immovable property. So, fish is considered as a profit ependre, a legal right allowing a person to extract something of valuable from another's land is regarded as a benefit arising out of the land, and it follows that it is an immovable property within the meaning of the Transfer of Property Act. So this is how the interpretation has happened in this case. a General Clauses Act was applied. I hope this gives you a clarity in understanding the thing. Now, Sushmita, transfer fishing rights is basically happens in all ponds, So you don't transfer the pond, you transfer the right of the right to fish in that particular pond for maybe 6 months or a year. This is called transfer of fishing rights. Across the country, this is how it happens. The people who are engaged in the fishing profession, they apply for tenders and they get that particular fishing rights in a pond. Like say, for example, you are owner of a pond, you don't want to rear the fish yourself, but you give that particular land, that particular pond for to someone to fish, then that right is referred to as the fishing rights. I hope this gives you a clarity. Okay, this is a very important right in our country, and there are communities who do fishing, and they apply for tenders across the country in government ponds and rivers, and that is how they do it. Okay, now let us move ahead and talk about another. Does the code constitute right to catch or carry fish as an immovable property? Now, the General Clauses Act application we will see, and it says this act may be called the General Clauses Act, and application, there is no application, it has been deleted as I told you before. So previously it used to be, it applies to all judicial proceedings in or before courts martial, but to affidavit it shall come into force on such date as official gazette appointed. So these are the provisions which were deleted. There is no need for these provisions now, and hence it was repealed. Uh, Applying General Clauses Act, one important thing you should always remember is that context is the king. So I always say whenever you are interpreting or you are looking at the General Clauses Act, you should look at it not in isolation. You have to look it in the context. So there are multiple things around. So law is made in context. Law is always enacted in context. Law is not done in vacuum. It is always having some context in picture. So this context is very important. A law, a particular word may have a different meaning in one context and may have a different meaning in another context. And hence, context is always the king. So you look at the situation, you look at the facts, and then accordingly interpret the law. That is why I say context is the king. So Article 367 of the Constitution of India authorizes use of General Clauses Act for the interpretation of Constitution of India as well. So if you see Article 367 of the Constitution of India, it says, unless the context otherwise requires, the General Clauses Act 1897 shall, subject to any adaptations or modifications that may be made therein, under Article 372, apply for the interpretation of this Constitution as it applies for the interpretation of an act of legislature of the Dominion of India, right? So I hope this gives you clarity. So you can see this picture comes from your course material, application of the GC Act. So it applies to acts of the Indian Parliament, Act of the Dominion Legislature. When I say Dominion Legislature, it is Government of India Act 1935, right? So the laws which were prior to our constitution, acts passed before the commencement of the constitution by the governor. So all these particular laws, the GC or General Clauses Act will apply. Any questions so far? Let me see your chat box if you have any questions. You can ask me any questions till this particular point. Any one of you? Any question you have? Yeah. Question? No. Okay, no question. Then let me proceed. And so I would like to give you some basic understanding of legislation, and you may have seen various legislations, but you may not be aware what does these things mean. So you can see this is a model or sample legislation which is published in Gazette of India. So any law which is, coming up, okay, Achal, I can be slow. Yes, definitely. But I don't know. I think I'm going a bit slow. But still, I will try to be more slow if you feel that it is fast. Okay. So, if you see understanding of legislation, this is a law or legislation which you are able to see here. This is Digital Personal Data Protection Act. Okay. Now, if you read it from the top, you will see it is written Bharat Ka Rajpatra, that is Gazette of India, and then this Gazette number is there, and then there is extraordinary part 2. This is the section of that particular Gazette in which it is published, and then you can see the date. So this is the date on which the law is published in the Gazette. Okay. So this date can be different than the date on which President gave assent to the legislation. So if you see, then next is Ministry of Law and Justice, that is Legislative Department, which generally, puts up the law for publication in the Gazette. And then there is date, and that date is basically the date on which the President gives the assent. So the Act of Parliament received the assent of the President on 11th August 2023. So this is the date on which the law is enacted, but this is not the date on which the law comes in force, by the way. Okay. So the statute may provide for different dates for enforcement of law. So the government may notify different dates for different parts of the law to be coming into force. So though the law is there in the books, it may not be in force. And DPDP Act is one of the greatest example because it is yet to come into force completely. Now let us see further, and you can see this is the continuous. Then you have got the preamble. So the law has a preamble. All legislation will have a preamble, which gives actually the context. As I was telling you, context is the king. So it is giving you the context of the legislation. So you can see here, what is the context? This law is saying that this is an act to provide for processing of digital personal data in a manner that recognizes both the right of the individual to protect their personal data and the need to process such personal data for lawful purposes and for matters connected therewith or incidental thereto. So this is the objective, or you can say preamble. And then you have chapter 1, and in the chapter 1 you have first section generally is short title and commencement and the extent of application. Short title basically is the law's title, that how you would refer the law to, or how you would name the law. If you have to name the law somewhere, or you have to write about the law somewhere, how do you write it? So that is coming by way of short title. And then if you look at the commencement and extent of application, commencement and extent of application tells that when the law will come into force. So you see here it is clearly written, it shall come into force on such date as the central government may by notification in the official gazette appoint, and different dates may be appointed for different provisions of this act, and any reference in any such provision to commencement of this act shall be constituted as a reference to the coming into force of that particular provisions. So as you can see here, so this is basically it is trying to tell you. Now it is extent of application is not mentioned here. There is no need for mentioning any other extent of application, but extent of application would generally say that it applies to whole of India. If there may be legislation which may say that it does not apply to a particular part. Okay. Then in laws, generally you will find a definition clause. So section 2 of the act there gives you the definition clause, and definition clause are exclusive definitions to that legislation. Like for example, if this is DPDP Act, and whatever DPDP Act defines, that definition would be applicable to the DPDP Act. Like for example, it is saying the child. Now the definition of child here is means an individual who has not completed the age of 18 years. So as per DPDP Act, child means a person who has not completed 18 years. There may be another legislation which gives you the definition of a child below 18 years also. So likewise, you have to see the definition. Like here, the definition of data is given. So data defined here means data meant for this act, not generally. But if a definition is there in General Clauses Act and there is no definition given in DPDP Act, then General Clauses Act can be utilized. The definition of General Clauses Act can always be utilized in DPDP Act. This is the beauty of General Clauses Act because it is general and applicable to all situations. But if there is a specific definition given in the statute, then the General Clauses Act definition cannot override the specific definition. I hope this gives you a clarity that, and this is also a very basic rule of interpretation, that special law overrides the general law. So in interpretation, if you have a special legislation, that special legislation will always take precedence over the general legislation, right? Okay. Now let us move further and talk about, yeah, this I have already told you. If there may be words which are not defined in the definition of the act, the meaning of such words can be taken from the General Clauses Act. This is an example. Okay. So if you see clause 95 of section 2 of the Companies Act, it clearly says that the words and expression used and not defined in this act, but defined in Securities Contract Regulation Act, Securities Exchange Board of India Act, Depositories Act, shall have the meaning respectively assigned to them. So Companies Act refer to these three legislations. So if you don't find a definition in Companies Act, you go to SCRA, that is Securities Contract Regulation Act. If you don't find it there, then you go to SEBI and Depositories Act. If you don't find in any of these places, you can also look at the General Clauses Act. I hope this gives you the clarity. Then there is something which is referred to as delegated legislation. So if you see the law, any act or any law, it also provides for delegated legislation. So what do you mean by delegated legislation? So delegated legislation is basically a legislation which are not enacted by Parliament, but the power is given to the statutory authority or government to make rules and any regulator to make regulations. These are referred to as delegated legislations. So if you see here in this provision, section 40 gives power to make rules. So central government may by notification make rules under the following provisions. This is what is a delegated legislation. In case of our company law, Ministry of Corporate Affairs is empowered agency for making rules. So central government here means the Ministry of Corporate Affairs. If you look at the DPDP Act, the central government, for me, I think it is Ministry of Electronics and Telecommunication, that is MITI. And regulations, who will make regulations? Regulations would be made by the regulators. Like, for example, we are having Insolvency and Bankruptcy Board of India. So IBBI makes regulations for whom? For multiple purposes, like insolvency professionals. If they are getting to be regulated, who makes the regulations? IBBI makes the regulations by virtue of the power given under the Insolvency and Bankruptcy Code. So this is how it works. Similarly, we have National Financial Reporting Authority for Chartered Accountants. They make many regulations and regulate the profession of chartered accountants. So this is how you can see there are a number of rules and regulations which are being made through delegated legislation. This gives us the background or backdrop of understanding General Clauses Act, and I hope you have understood this particular part briefly. But before I move on, can you give some example of difference between Act, rules, and regulations? So Mehak, your point I have listened, and we are actually I'm going through your course material only. So I have curated this particular lecture by reference of your course material. So whatever is your study material, there may be certain additional information which I am sharing, but that is for your understanding. Because if you understand this context and this frame, it will be easy for you to understand the General Clauses Act. So you just keep following your literature, which you have in front of you, and you will completely relate to it. Okay. There are certain things which are not there in your literature, but it is important for you to understand the interpretation and General Process Act. Like, for example, the few 3-4 slides which I explained you about the difference between Act, rules, regulations is quite basic, very important, and you must understand what is the difference of that. So if I may ask you a question, what is the difference between Act, rules, and regulations? Can you give an example or can you explain? Any one of you? You can utilize the chat box, and I would request the IT team, if you can permit them to speak also, it's okay. Yeah, go ahead. Okay, Act defines, Isha says, Act defines laws and rules says how to enforce laws. Not exactly, Isha. Rules means which made by central government, it is deemed legislative. Okay, Sridhar. Act is a law that is formally passed by legislature, such as parliament. This is Anchal. Okay, good, very good. This is how the act is. The act is always passed by the parliament, okay? Or the state legislature, that will be act. Means this is the legislature which passes, that is act. Whom? The central government and the regulators to make rules and regulations. What is the distinction between rules and regulations? Rules are always made just one level below the legislature, that is executive. So central government, whenever a power is given to central government to make rules. So they make rules, and regulations are made by the specific authorities. Like, for example, IBBI, National Financial Reporting Authority. So they make the regulations. So ICAI will be able to make rules or regulations. Regulations. Very good. Very good. Very good. So all of you have understood now. So who will make the rules for ICAI? MCA. Very good. MCA. Correct. MCA will make regulations for rules for ICAI. NFRA will not make, Sushmita, rules. NFRA will again make regulations. That is a parallel body which is there now, which has got a specific mandate to look into the financial frauds or auditing frauds. So they are coming up with their own regulations as well. But Ministry of Corporate Affairs is the empowered authority to make rules under the legislation. Very good. So now I think you have understood this particular part. Now let me move further and talk about the General Clauses Act Section 5, which talks about general rules of construction. So there is a general rules of construction which are given in Section 5, and these are quite an interesting rules. So see, let us read that. It says, where any central act is not expressed to come into operation on a particular day, then it shall come into operation on the day on which it receives the assent. Okay? Assent of whom? In first case, in case the central act is made before the commencement of the constitution, the governor general, and in case of an act of parliament, of the president. Unless the contrary is expressed, a central act or regulation shall be construed as coming into operation immediately on expiration of the day preceding its commencement. So, say for example, there is a commencement which is happening on today is 6th of June. The president gave the assent. So when the law will get commenced? 7th of June. The law will start commencing. Unless the law says that this will get notified or will be informed by the central government later, then commencement provision, if says that, okay, fine, it will come into effect on so and so date, then that will come into so and so date. Okay. So this is what the coming into operation of enactment provision section 5 says. So Supreme Court in A.K. Roy versus Union of India observed that where an act empowers the government to bring any of the provisions into operation on any day which it deems fit, no court can issue a mandamus with a review to compel the government to bring the same into operation on a particular day. So this is a very interesting case wherein they said that you cannot compel the legislature to bring the legislation immediately or on that particular day. However, the courts have been very innovative and they have been issuing directions. So, like for example, in Vishakha versus State of Rajasthan, they issued an immediate direction which was complied to be, right? But these are some extreme situations, not in a routine manner. The court will not direct the government to bring in a legislation into force on a particular date. There is one interesting principle which comes from this particular law, right? So let us, but before that, let me give you this example. Okay, so you have in your study material this example, example 18. So you can see here, it says the Companies Act 2013 received assent of President of India on 29th August 2013 and was notified in official gazette on 30th August with the enforcement of Section 1 of the Act. Accordingly, the Companies Act came into enforcement on the date of its publication in the official gazette. There is another example given in your book is SEBI issue of capital and disclosure requirements. Fifth Amendment Regulation 2015 was issued by SEBI, wide notification dated 14th August 2015 with effect from 1st January 2016. So see here, the regulation came into effect only on 1st January 2016 because the law specifically said that it will come into effect on a particular date. But now I am talking about an interesting principle, which is saying presumption against prospectivity. So what do you mean by this? Any one of you would like to explain? What is this presumption against prospectivity? Yeah, presumption against prospectivity. Go ahead. Okay. So it is presumption against retrospectivity. So retrospective means from the previous date. So this is a basic norm that the law applies from future. So law applies from future. So you cannot law cannot apply from the back date. So if there is a law which is enacted today, you cannot make it applicable from the back date generally. Okay, unless there are some situations wherein you can say that okay, fine, it applies from the back date. But very rare situations. So generally the law will apply from the future date. So if a law is passed today, then the law can apply from today onwards, not before that. This is called presumption against retrospectivity. So this presumption, any law which does not mention that the law is applicable from a prior date, in that situation, it will be a presumption that the law will apply from the future date. And that is how it works. As I was telling you, another example is of this digital personal data protection rules, where you can see the law is coming from in effect from different dates, right? So these are the rules under DPDP Act, DPDP law. And you can see Rule 1, 2, 17, 21 came into effect on 13th November 2025. And Rule 4 is going to come into effect on 13th November 2026. And the remaining provisions will come into effect on 13th May 2027. So this is how the, different times. What is the logic? Logic is that the law requires some time to be, enforcement machinery should be there. Like, for example, in digital personal data protection law, there is a manager. Amendment retrospectively. Raghav challenges the order. So if you are a lawyer of this particular person, what is your argument? Do you think that the fine will sustain 5 lakh? And if yes, then why? Okay, good. So, Sushmita, your answer is seems to be good. Okay. Achal, you are saying between 5 to 50, how? 50K to 5 lakhs, how it will be? So you can see here, the amendment imposes a new and heavier penalty which affects substantive rights. Substantive laws are presumed to be prospective unless the statute expressly states otherwise. There is no express intention for retrospective application. Retrospective operation would violate principles of fairness and legal certainty. So the enhanced penalty cannot apply to Raghav 2023 conduct. So penalty will be only 50,000. However, if the law says that even for previous conduct, the penalty will be this much, then it can be imposed. Okay. But this law will be subject to challenge under fundamental rights, part 3 of the constitution. Anybody will challenge it because in criminal matters, you cannot have fines from the previous state. Okay. I think this is a criminal law which yeah, applies here. Okay. Okay. Now let us move ahead and talk about another important perspective, that is meaning of some terms. So if you will see in your book, we are talking about a very important term which many a times comes, and it is also there in your General Clauses Act, that is means and or include. So these are two words which are most of the times utilized in legislation, and means have a restrictive interpretation, and and includes has an extensive interpretation. So if you see, the legislature has power to define a word even artificially. So the definition of a word in the definition section may either be restrictive of its ordinary meaning, or even it may be extensive. So when a word is defined to mean such and such, the definition is prima facie restrictive and exhaustive. Whereas the word defined is declared to include such and such, the definition is extensive in nature. So you can include many more words into it. But if it says means A, B, C, you cannot include D into it. Okay. So when by an amending act, the word includes was substituted for the words means in a definition section, it was held that the intention was to make it more extensive. Further, a definition may be in the form of means and includes, where again the definition is exhaustive. On the other hand, if the word is defined to apply to include, the definition is understood as extensive. These meanings of expression means, includes, and means and include have been reiterated. So this is the case law. If you want to read more about this means and includes interpretation, you can refer to Delhi Development Authority versus Bholanath Sharma in 2011. Let us look at some examples which is there in your course material. So definition of company as given in section 2 subclause 20 of the Companies Act states company means a company incorporated under this act or under any previous company law. Now here you cannot include a partnership firm here, okay? Because it specifically says two situations of meaning of company law. Now section 234 of the Companies Act defines the term director, and it says director means a director appointed to the board of a company. So you cannot have any other director Director means a person who is appointed to the board of the company. This is a restrictive meaning, restrictive. So wherever you find the word means, it is restrictive in nature. Now, wherever you find the word includes, it may have something, it will have an inclusive nature. Like, for example, the word debenture, which is defined in section 2, subclause 30 of the Companies Act, states debenture includes debenture stock, bonds, or any other instrument of a company evincing a debt. So you can see it is a broader, it is open-ended. So you can have other names also like derivatives or maybe something else. Whether constituting a charge on the assets of the company or not. So this is a definition of inclusive nature. Similarly, body corporate or corporation includes a company incorporated outside India. Under section 2, subclause 11, this is what is referred to as body corporate or corporation. Body corporate or corporation. So it may it includes a company incorporated outside India. It can include company incorporated inside India, like that. I hope this gives you the clearly. Okay, so means restrictive and extensive. Okay. Now let us look at them, and if you see some of the examples, let me give you one example. So section 2, subclause 12, executed and execution. So used with reference to instruments means signed and signature. So here when I say mean, that means it is a specific. You cannot include any other words into it. If you see instrument, definition of instrument, it says instrument includes every document by which any right or liability is or purports to be created, transferred, limited, extended, extinguishing, or recorded. So you can see so many words used. So it may include similar kind of a word also. So instrument includes is extensive. Now, if you see here, there is a definition of lease. These are all definitions coming from Transfer of Property Act, by the way. So the lease means a lease of immovable property and includes, right? So you can see here, it has got two things. One is means and includes. So it is saying that lease will means lease of immovable property and it has nothing to do with movable property, but it includes what? A patta, a kabuliyat, or undertaking in writing, not being a counterpart of lease to cultivate, occupy, or pay or deliver rent for immovable property. So this is how you read this. Similarly, if you see one of the case laws, that is Nasruddin versus State of Uttar Pradesh Secretary, this is what was dealt with under that particular law. But in one of the case, that is Bharat Cooperative Bank versus Cooperative Bank Employees Union, the court said, wherever the expression means is followed by the expression and includes, whether with or without additional words separating means from includes, these expressions indicate that the definition provision is exhaustive as a matter of statutory interpretation. It has also been held that expression and includes is an expression which extends the definition contained in the words which follow the expression means. So you can, I think you have got the distinction between expression means and includes. So when I say means, it has got specific meaning. So say, for example, I say X means 1, 2, 3, 4. You cannot include 5 into it, right? And if the definition has the word includes, so if I say the X includes or X, the definition of X includes 1, 2, 3, you can have 5 in it or 4 in it, right? So this is how the definition difference between means and includes. And if means and includes, both of them are together used with and, then it is an exhaustive definition. So mean is there, but since it is used with includes, it will be an exhaustive definition and you can have more liberal interpretation of the word. So this is how this means and includes are interpreted. I hope this gives you clarity. Let us look at some more terms. Okay, so and these are the terms which you will be referring to, and this many a times it comes. So in English, we used to read the words called modal verbs, right? So can, could, may, might, must, ought, shall, should, will, would. These are the words. These are called modal verbs, which basically dictates the mood of the sentence. So modal verbs are auxiliary verbs, and they express the mood, attitude, or possibility of an action rather than the action itself. And in law, we use a lot of modal verbs, particularly shall and may, many a times. So the word shall is used to raise a presumption of something which is mandatory or imperative. Okay. While the word may is used to connote something which is not mandatory but is only directory or enabling. Till this point, it is quite easy. You can say that shall means mandatory, may means non-mandatory, or it is directory. It can be mandatory or cannot be mandatory. However, the challenge comes when the words may and shall can be interpreted interchangeably depending upon the intention of the legislator. So here comes the challenge. So, and most of the court cases are fought on this particular interpretation part, wherein the legislature has used the word shall, but you want to convince the court that it should be interpreted as may. And many a places the word has been used as may, and you want to convince the court that it should be interpreted as shall. And their situation exists in which the court has interpreted shall as may and may as shall. So you have to see the context. And that is why in the beginning, I told you that context is the king. So in the context, you have to have a look at it. Let us look at this particular Supreme Court decision in Dinesh Chandra Pandey versus High Court of Madhya Pradesh. Okay. So this was a case where the court looked at it and the court said, and it referred to many decisions of different courts, and it said the courts have taken a view that where the expression shall has been used, it would not necessarily mean that it is mandatory. It will always depend upon the facts of a given case, the conjunctive reading of the relevant provisions along with other provisions of the rules, the purpose sought to be achieved, and the object behind the implementation of such provisions. So you see, they are going ahead with the purposive interpretation of the law. So this court in Sarla Goel versus Krishnachand took the view that where the word may shall be read as shall would depend upon intention of the legislature, and it is not to be taken that once the word may is used, it is per se directory. In other words, it is not merely the use of the particular expression that would render a provision directory or mandatory. It would have to be interpreted in the light of the settled principles, and while ensuring that intent, the rule is not frustrated. So you look at the purpose of the interpretation while interpreting may and shall. I think by now I have confused you a bit as far as may and shall is concerned, but that is how the law is confusing. Okay, so you have to have a look at from the context. I can give you one example. So in the law, if you see NCLT law provides that the court shall decide the matter. NCLT shall decide the matter within 310 days or 20 days, something is written there. Okay. So, and in most of the cases, NCLT does not decide that particular matter within that statutory limit. So the matter went to the Supreme Court and it was said that whether it is a mandatory provision. The court said that it cannot be a mandatory provision because you cannot direct a court to decide the things in such and such a date. So that is how the provision of shall was interpreted as may. There are some examples which are there in your, course material. And if you see example 14 says section 3 of the Companies Act states that a company may be formed for any lawful purposes. Now here may shall be read as shall. Why? Because may here is mandatory for a company, for the compliance, for the formation of a company. It is not at the discretion that you can form a company for lawful purposes only. You cannot form any company for unlawful purposes, right? Now, section 21 of the Companies Act provides that the documents proceeding requiring authentication or the contacts Contracts may made by or on behalf of the company may be signed by a key managerial personnel or an officer of the company duly authorized by the board in this behalf. Now here usage of may shall be read as may. Now here this may is read as may because it can be KMP, it can be any other person duly authorized by the board in this behalf. This is another case, that is Vidarbha Industries Power Limited versus Axis Bank Limited. And in this case, they further quote looked at it and it said, ordinarily the word may is directory. The expression may admit confers discretion to admit. In contrast, the use of the word shall postulates a mandatory requirement. The use of the word shall raises a presumption that a provision is imperative. However, it is well settled that prima facie presumption about provision being imperative may be rebutted by other considerations such as scope of enactment or consequences, etc., etc. So in IBC, so there was a provision with reference to the word with reference to application for CIRP initiated by financial creditor against corporate debtor. But if you see, there is a difference between the application in case of financial creditor and operational creditor. In case of financial creditor, they have used the word shall. In case of operational creditor, they have used the word may. And the court said that the legislature used may in section 7(5)(a) of the IBC, but a different word, that is shall, in 9(5)(a) shows that may and shall in two provisions are intended to convey different meaning. It is apparent that legislature intended IBC to be mandatory and 7(5)(a) of IBC to be discretionary. This is what was held in Vidarbha Industries Power Limited. If you would like to read more on this shall and may debate, there is an interesting article in Bar and Bench on shall shocked the use of shall in legal documents. So please go through this literature. It is a quite an interesting literature for all of you. This is a problem for you. You can have a look at it, please, and let me know the answer. Okay, so what is the question? Question is Ayush and Vipul are good friends and pursuing CA course. While doing group studies for the paper of corporate and other laws, they are confused about the provision of Section 3 of the Companies Act. Any lawful purposes. Yeah, it should be taken as mandatory. Okay. Good. This we have already discussed, right? So this is how it is. So here, in case may should be taken as mandatory force because the law will never allow the formation of a company with unlawful object. Here the word used may shall be read as shall. Usage of the word may here make it mandatory for the company for compliance of Section 3 of its formation. Let us look at this. Mr. M owned a land with 50 tamarind trees. He sold his land and the timber obtained after cutting the 50 trees to N. Now, M wants to know whether the sale of timber tantamounts to sale of immovable property. Advise him with reference to General Clauses Act. This we have dealt with. I can give you a hint. The fish point, which you remember, fish point, immovable property. So apply that. Let me hear. Wow, what is your answer? Sale of timber is okay. I think after looking at the picture, you will be able to answer it. So immovable property, section 326. So it contains four elements. Land this. Here in this case, you can see M sold land along with timber, obtained after cutting trees of 50 tamarind trees. According to the above definition, land is immovable property. However, timber cannot be immovable property since the same are not attached to the earth. Okay. If the question would have been like this, then in this case, probably the trees are attached to the earth and hence it is immovable property. So if it is attached to the tree, then it is an immovable property, otherwise not. Right? Okay, friends. So we will take a break here and we will meet at 7:35. Okay. In the meantime, you can brush up your course material, and if you have any specific questions, turn out to me. I will be happy to answer them specifically. Uh, and we will continue with this session at 7:35. IT team, you can announce the break. Welcome back. So we still have 3-4 minutes from the announced time, but let us have a quick recap what we have studied till now. So we began with the General Clauses Act. I gave you the brief background of the General Clauses Act as to what are the major parts of General Clauses Act. That is 6 parts which we saw, and 30 sections are arranged in these 6 parts. Uh, we also saw the objective and rationale for the General Clauses Act, why it is brought into picture. There are 4 or 5 objectives with which the General Clauses Act is enacted. One of them is to avoid repetition. All throughout the central legislations, you don't have to repeat the provisions, and to provide clarity, provide for certain basic rules of construction under the General Clauses Act. So we saw that. I gave you a brief understanding of a structure of a legislation, starting from its short title, commencement, preamble, definition clause, and the difference between act, rule, and regulation. We also saw the definition of law under Article 13 of the Constitution and how it relates to the Constitution, and why not a legislation shall infringe upon the fundamental rights of the people, because if they do that, then that law can be struck down on the grounds of constitutionality. This is something which we saw. We also saw a specific definition on immovable property. Now, through these examples, you have come to know the difference between movable and immovable property. Immovable property includes even the rights to get something, like a fishing rights will be referred to, or any benefits arising out of the land is considered to be the immovable property, or any things which are attached to the earth or permanently fastened to anything attached to the earth will be referred to as immovable property. So say, for example, there is a telephone tower which is attached to the earth permanently, that will be part of the immovable property if you are dealing with a property, or maybe for that matter, a machinery or a plant which is there, that will be referred to as immovable property. So this is a situation which comes out of there. Now, Sushmita has an interesting question. Why can't we consider timber as a benefit to arise out of the land? That's an interesting question and a good question which you have asked, but that is how the interpretation is. It may be considered as benefit arising out of the land till the point the tree is not uprooted. If the tree is uprooted, then that will not be considered as a benefit arising out of the land, because imagine a situation that I take 5 or 6, Achal, it is not because of harm to environment. But say, for example, I take 5 or 7 timber, cut timber, and take it somewhere. So that does not mean that that particular timber is representing the immovable property in which it grew, right? So once you detach it from it is just like, fish. So once you detach the fish from the pond and take it to a market, it is an immovable property, isn't it? It is only the right to fishing in that. So benefits arising out of that particular land would be referred to as immovable property. So like, for example, I can say that if you have land and you have right to raise crop in that particular land, or maybe there is a standing crop on that particular land, that will be referred to as immovable property, but not once the crop is cut, then that will be referred to as movable property. I hope this gives you some amount of clarity. Okay. In case if you still don't have clarity, you can ask me. Okay. Now let us move further and talk about the provision of General Clauses Act, the remaining ones. So if you see a preliminary section of the General Clauses Act, it says this act may be called the General Clauses Act 1897. And preliminary is basically the introductory part of any law, which generally contains a short title, extent, commencement, application. This I have shown you with reference to DPDP Act. And the title, although the part of the act is in itself not an enacting provision, every act is given a title to carve out its own identity, just like people are given their names to identify them. So the General Clauses Act contains only short title in the preliminary part of the Act. That is called the General Clauses Act 1897. Section 2 is repealed because that is no more needed after the Kashmir Reorganization Act. Now, Section 3, 4 and 4A of the General Clauses Act talks about definitions. So it gives many definitions and we will see these definitions one by one. So Section 3 defines many terms, and it says in this act and in all central acts and regulations made after the commencement of this act, unless there is anything repugnant in the subject or context. So this term you will find many places, okay? That is anything repugnant in subject or context. That means anything which is contrary to the subject or context, or anything which is beyond the words which are mentioned in the definition. So you have to see it from that perspective. Generally, so if you want to read it in a simpler way, it is saying generally the word act will mean these things. If there is some specific situation, that will be specifically told in the definition, or there may be an exception to that particular definition. Okay. So now let us look at this is basically legal language, and you have to look at it from that particular perspective. Okay. So this is how we look at this. Now let us move further and talk about the definition of act. So if you look at yes, Achal, you have asked for a question on what is the meaning of the repugnant. Repugnant is basically, it means which is unacceptable, or which is not acceptable to the norm. So if it is not acceptable within the meaning of that particular context, then that will not be considered as its meaning. This is what it means. Okay. So let us look at article act is section 3 subclause 2. It defines act, and it says act used with reference to an offense or a civil wrong shall include a series of acts, or the words which refer to the acts done extend also to the illegal omissions. So generally this definition of act, ACT, will include even omissions. So if lawfully you are required to do something and you have not done that, that will be also be an act. It is not an omission. So omissions are always included in the definition of the act. So it is saying it is with reference to a civil wrong and shall include a series of. So it is not a criminal wrong, by the way. So act, the definition of act under criminal law, you will find under IPC, now Bharatiya Nyaya Sanhita. So this act definition under the General Clauses Act is only referring to civil wrongs, not criminal wrong. Act definition of act under the criminal law is a different act, because there it has to have the actus reus and mens rea. So there is a criminal law operates differently, and the General Clauses Act generally is making application to the civil laws. That is what it is trying to convey here. So here the act with reference to offense or a civil wrong, an offense or a civil wrong shall include a series of acts or word which refer to the acts done extend also to the illegal omissions. So if you are doing an omission, that will be included in the definition of the act. Now section 3.3 talks about affidavit. So affidavit you must have heard. Affidavit, most of the times you have to give an affidavit in court, and affidavit shall include affirmations and declaration in the case of persons by law allowed to affirm or declare instead of swearing. So there are three terms which are used here, right? One is called affirmation, second is called declare, and third is called swearing. So whenever you use the word swearing, swearing means you are a religious person. You are swearing in the name of God, or you are swearing in the name of a person, or you are swearing in the name of a, what you can say, religious text like Gita, Quran, or maybe Bible. When you are saying affirmation or declaration, it is basically your own will by which you are affirming. You are making a statement and standing by it. So making an affirmation or a declaration is considered, statutorily a very important thing, because nowadays you can see our all laws are declaration based, right? So you declare that, okay, fine, we have complied with the laws. So most laws are now on a declaration base, self-declaration base. They don't, ask you to give an affidavit. It is a self-declaratory law which, works. So that is the difference between these three terms. So affirm or declare is on one side and swearing is another side. So whenever one person says oath, oath can be taken by affirmation and declaration in case of persons by law allowed to affirm or declare instead of swearing. Okay, so one person can take a oath by affirmation and declaration also. There is no need for a swearing. Or a person can swear an affidavit. So they can swear an affidavit by, with its grammatical meaning that it's affirming and declaring and swearing the thing by saying that, okay, fine, in the name of God, I hereby swear. So this is how these three terms are utilized in case of affidavit. So generally, you will see in an affidavit, there will be a declaration part wherein you say that I affirm or I declare, or you say I swear in the name of God that the following things are true and nothing is hidden, something like that you state in the affidavit. I hope this is clear to you. It is self-explanatory, not very much difference. Now there is a definition under the General Clauses Act of month, year, and financial year. So you will see the month is defined in clause 35, and it says it shall mean a month reckoned according to the British calendar. So the reference here is to the British calendar. And you will see in India, we are referring many types of calendar. For example, if you go to traditional merchant houses, they are using their Saka calendar or other calendars. But as far as the law is concerned, we are all using British calendar. That is, or we are also using British calendar, that is January to December. And then there is year. Year shall means reckoned according to the British calendar, and financial year shall mean the year commencing on the first day of April. So this is our financial year, and we calculate it according, you all know, first day of April, 31st March, it closes. So this is one question for you people. So if you can just read and respond. It is saying a confusion regarding the meaning of financial year arose among the financial executive and accountant of a company. Both were having different arguments regarding the meaning of financial year and calendar year. What is the correct meaning of financial year under the provisions of General Clauses Act? How it is different from calendar year? Yes. I think the answer would be very easy for you because I have just explained. This is a question which has come in one of your examinations, CA examinations. Probably of 2 or 4 marks. Right, Daksh? Yes. Good. So you people all have got it. Very nice. So this is what is the response. So financial year, according to section 321 of the General Clauses Act, financial year shall mean the year commencing on the first day of April. The term year has been defined under section 366 has to be reckoned according to British calendar. Thus, as per the General Clauses Act, year means calendar year, which starts from January to December. So the difference between financial and calendar year is that financial year starts from first day of April, but calendar year starts from the first day of January. Good. Now there is a definition of central government. So if you see under the clause, the central government is defined, and central government, if you look at the definition, it talks about two kinds of central government. One before constitution and one after constitution. So the constitution came into force in 1950, And before the constitution, the central government was basically the governor general in council, and under the Government of India Act, there were provincial governments and those things. So these are all people who were referred to as government, central government. And after the constitution, the central government is clearly defined, and it says in relation to functions entrusted under subclause 1 of 258, the government of a state or the state government acting within the scope of the authority given to it under that clause. Now, in relation to the administration of Part C state before the commencement of the Constitution. So I don't know how many of you have read constitutional history, but if you will see, we had Part A, B, and C states before the Constitution, before we consolidated and the Constitution came into force. All states, all different types of states came together, but still we are having this northeast states as a different nature. So you can see here there were Part A states. These were former British provinces, like 9 states were there coming from there, and then Part B states included Hyderabad, Jammu Kashmir, Madhya Bharat, Mysore, Patiala. These are the different Rajwadas and Rajas who merged into India. And then there were Part C states. These were state provinces like Ajmer, Coorg, Bhopal, Bilaspur, Delhi, Himachal Pradesh, Kutch, Manipur, Tripura. And then Part D was an union territory, that is Andaman and Nicobar Islands. Now, our differentiation is state and union territories, right? So this is what it is referring to. Then if you will see in relation to administration of union territory, it is basically the central government which is there, which has the power to deal with that. So government shall include both central government and the state government in the definition here. So if you see, you may have a question that why we are reading this particular clause, is it necessary, and whether these clauses are utilized for interpretation. To your surprise, these provisions are still interpreted, right? So, like for example, in the Reorganization Act, wherein there was a dispute between the Lieutenant Governor and Delhi, these provisions were brought into force to have a interpretation clause. Similarly, in the matter of Article 370, these questions came up and General Clauses Act was referred to. I could find one case law this is Goa Sampling Employees Association versus General Superintendent's Company. Interestingly, see, in the interpretation of Industrial Disputes Act, the General Clauses Act has come up, right? So if you see this case, Goa Sampling Employees Association General Superintendents, this is 1985 case, okay? And here the question was with reference to interpretation of appropriate government. So Industrial Disputes Act refers to appropriate government. The question here was that who would be appropriate government? The central government or the union territory or the state government? Who should be the, appropriate government? So here the court went into the interpretation and it referred to the Industrial Disputes Act, and it, made a reference to General Clauses Act and said that General Clauses, must receive the meaning assigned to the General Clauses Act. And it considered the provisions of Union Territories Act of 1963 and the Goa and Daman and Diu regulations. And then it said the expression administration of a union territory, administrator howsoever has been described, would not be comprehended in the expression state government. So administrator is not a state government. Here the state government would be equivalently referred to as central government. So in case of all union territories, union has got the power as the state government. So this is quite an interesting interpretation which was brought up, and you can see the application of General Clauses Act while interpreting the provision. I hope you are understanding this particular point. Any confusion on this? Are you able to understand what I'm trying to say? You can put it in the chat box if you have understood it. Otherwise, I will explain it again. I'm explaining the point that why General Clauses Act is important and how it is getting interpreted in different situations. So here you can see here that this General Clauses Act has been utilized for interpreting the provision of Industrial Disputes Act, right? And Industrial Disputes Act is a central legislation. Now, though it has changed, now we have come up with a new labor code. Okay. Right. So if you have understood this, we will move further. This is another one. That is the definition under section 3.7. It says Central Act. So Central Act means Act of Parliament and shall include an act made before such commencement by the Governor General in Council or the Governor General acting in a legislative capacity. Okay. And an act of the Dominion Legislature or of the Indian Legislature passed before the commencement of the Constitution. So this is what it is talking about, the Central Act. Now, there is a definition of Indian law. Interestingly, you find this definition probably after independence. If General Clauses Act would have come up, it would not have defined Indian law. But it was necessary at that point in time because it was pre-independence and many of the British laws applied to India. And hence, there was a need for definition of Indian law. And it basically says that it shall mean act, ordinance, regulation, etc., which before the commencement of the constitution has the force of law in any province of India, and so and so. So this is not very much important. Then you have a few more definitions like enactment. And it says it includes regulations and any regulation of the Bengal, Madras, or Bombay court. So you may be knowing that we had three governments at that point in time, three Supreme Courts, right? So one was in Bengal, one was in Madras, and one was in Bombay. And these are all principal courts also. So include any provisions. This is British era. Then section shall mean section of an act or regulation. And subsection shall mean subsection of a word occurs. Rule shall mean a rule made in exercise of power conferred by the enactment and shall include a regulation made as a rule under any enactment. And then schedule. So you may have seen schedule. So in act, we have schedule, regulations, we have schedule. Schedule is basically the detailing of it, right? So in a Companies Act schedule, if you look at it, there are forms which are there in the schedule. So schedule shall mean schedule to the act or regulation in which the word occurs. I hope these are self-explanatory definitions. We don't require much of a interpretation or much of a discussion here. Then there is a term which is referred to as commencement. So on commencement, I think we have already had a discussion. I explained you that the law may come into force immediately or the law may come into force at a later point in time. So the commencement of the law can be decided by the central government. Okay. So here 3 subclause 13 of the General Clauses Act defines commencement, and it says commencement used with reference to an act or regulation shall mean the day on which the act or regulation comes into force. I gave you an example of DPDP rules. So it is coming in 3 phases into force, right? So the law will finally come into force on 13th May 2027 when the remaining rules get notified. Subclause 39 talks about official gazette or gazette, and it says that shall mean the Gazette of India or the official gazette of a state. Then you have the definition of document, and it defines in subclause 18 document, and it shall include any matter written, expressed. So the definition of a document you will also find, if you don't want to go to the General Clauses Act, document is also defined in Evidence Act, by the way. Okay. So Evidence Act defines document, and document includes written. So here you can see document is given a definition, and it says it includes any matter written, expressed, or described upon any substance. So it can be any substance, right? Even on a leaf, if it is something is written, that is a document. If, say, for example, there is an utensil. On a utensil, if something is written, that is a document. Or maybe your fingerprint is imprinted on a glass, that is a document. So these are all documents. So it can be substance is immaterial. It can be wood. It can be, anything. By means of a letter or figure or by more than one of those means that will, so it can be a letter, it can be in any language, it can be any mark or a figure, and which is intended to be used or which may be used. So if you are using it or you may be using it for the purpose of recording that matter. So that is referred to as, now I am getting reminded of an interesting situation because now examinations are going on in all universities. And you see UFM cases, that is unfair means cases, okay? And you will find many of them will write in their hand, or maybe they will be writing on their, notepad. I think you could relate these. These are all documents. So even written on hand, that is also a document. So you maybe there is something which is written on mobile or maybe a calculator. These are all documents for the purpose of recording that matter. So I believe the document definition you have referred to, it is a quite exhaustive definition. It includes many things. Uh, Criminal face is also a document. Criminal's face, no, criminal cannot be a document. But yes, if his photograph is there, that is a document. And if it is, caricature or made any drawing, that is, these are all documents. Okay. Now let us talk about the writing. So the expression referring to writing shall be construed as including references to printing. Writing means printing, lithography, photography, and other modes of representing or reproducing words in a visible form will be referred to as writing. Nowadays, you can include the electronic means also into this. So document includes even electronic documents nowadays. Now, let us move further and talk about another definition, which is of government securities. So, government securities is defined and it says it shall mean securities of the central government or of any state government, but in any act or regulation made before the commencement of this constitution shall not include securities of government of any Part B states. So, it excludes the securities of the Part B states. So generally it is saying that any document, say for example, Maharaja of Hyderabad has issued some security, that central government is not going to recognize. Okay. So this is what is the definition of government securities. You may have seen government securities includes bonds, government bonds, or maybe sovereign bonds, gold bonds. These are all government securities. Then there is a definition of immovable property. I think we have had a longer discussion on this immovable property, and you get many times a question on this. So it includes land, benefits to arising out of the land, and things attached to the earth or permanently fastened to anything attached to the earth. So there are 4 points in the definition of immovable property. One, it is land. Second, it is benefits arising out of the land. Third, it is things attached to the earth. And fourth is permanently something which is fastened to the attached to the earth. That means a factory or a big machinery. These are all considered to be immovable property. Then movable property. It means property of every description except immovable property. So in law, it is quite an interesting definition. Okay. So many a times you define by way of exclusion. So what is a public company, which is not a private company, is a public company. Right? So this is what is the definition. Likewise, your movable property definition is there, where it is saying movable property mean property of every description except immovable property. I hope this is self-explanatory. Let us move further. Then there is a definition of registered. So it says registered is used with reference to a document shall mean registered in India under the law for the time being in force for the registration of documents. Can you tell me which is the law which is there for registration of documents? Any one of you? Which is utilized for registration of documents? Which laws you utilize for registration of documents? Just out of curiosity. This is not part of your syllabus, but still. The law which is utilized for registration. Indian Stamp Act. Okay, yes. Registration Act. Very good. Registration Act is the law. And Indian Stamp Act is definitely, that is also the law. And Transfer of Property Act also utilize the term registered. Okay. So these are the three legislation in which you use the word registered. Okay. Now let us move further. There is a definition of person. Person is defined and it includes even legal person or association or body of individuals, whether it is incorporated or not incorporated. So this person under the General Clauses Act would include partnership firms, LLPs. These are all included. Hindu undivided family. These are all persons. Then good faith. This is a definition which is very much there and it defines a thing shall be deemed to be done in good faith, where it is in fact done honestly, whether it is done negligently or not. So you can see the definition of good faith excludes negligence. So it says that if it may be have been done by negligence, but honest intention is there for doing that particular thing. So even if it is honestly done, then it will be considered as good faith. Okay. So I have a case law on this. I will explain you in a while. But there is a definition of offense, and offense shall mean any act or omission made punishable by any law for the timing in force. So this is an offense. Then imprisonment shall mean imprisonment of either description as defined under Indian Penal Code. Now it is Bharatiya Nyaya Sanhita. Okay. So this is the definition. Give me a second. Let me note it down to make a correction here. Okay. Now let me further move. And this is the case law which I was talking about. Okay. On good faith. So if you see, this is Rabia Bai versus Custodian General of Evacuee Property. It is 1961 case. And here the question was interesting. Okay. So I will give you the context of this. So this evacuee property law was there because when partition happened, after partition, there were people who went to Pakistan who had property here in India. So there was some law which prohibited from them from selling the property and taking the money to Pakistan, okay, of those particular land. So here this lady actually sold the property and wanted to take that particular money to Pakistan, okay. And when this was objected to, so they made an argument that the selling of that particular property was by in good faith. So here the court interpreted the term good faith and it said that it cannot be good faith because you were trying to circumvent the law. So there was a law which prohibited you from, selling that particular property, and you sold that particular property just because to evade the law. And hence it cannot be considered as good faith. So you can see here in para 10, there is an argument on the basis of good faith. So they are saying that they are trying to make a case for themselves that the action which was taken by Rabia Bai was in good faith. But the court interpreted it that no, it cannot be in good faith because you have, utilized this particular law for, what you can say, misappropriating that particular property. And they also look at the context. So they did not look at General Clauses Act. They said that go back and see section 44 of that particular legislation, which talks about the custody of evacuee properties. And if we agree to that particular provision, then you are breaching the provisions and it cannot be considered as good faith transaction. So this is another example as to how General Clauses Act are brought for interpretation of different legislations. I hope this, substantially establishes the point which I was trying to tell you before about the usage of General Clauses Act. Is it making sense to you? Have you understood this case law? Yeah. Okay. Good. Now let us move further and talk about another point. And this point is talking about application of foregoing provisions to previous enactments. So basically this provision is, broadly you have to understand there is not much to interpret in this. It is saying basically that these definitions, the different definitions which are provided under section 3 will apply also to the Central Act made after 3rd January of 1968. So you would be, I would just give you the context why this provision is there, because the law got consolidated. The General Clauses Act of 1897 came only after 1868 and 1887. So there were many legislation which were brought up in between this period also. So this provision is basically trying to say that any laws which have been incorporated in between 68, 87, the provisions or the definition of this General Clauses Act will apply to them as well. So from your perspective, I think this is not very relevant section to remember or is of consequence. I don't think any question can come on this. Let us move further. Similarly, this application of certain definition of Indian laws. So it is saying the definition in section 3 of British India, etc., etc., shall apply unless there is anything repugnant in the subject or context to all Indian laws. So it is referring to constitutional provision. And if you see any Indian law referenced by whatever form of words to revenue of the central government or the state government shall from the first day of April 1950 be constituted as references to Consolidated Fund of India. So prior to April 1950, the Consolidated Fund of India was not there because Constitution did not came into force. Constitution brought Consolidated Fund of India into force. Article 226 of the Constitution of India talks about consolidated funds and public accounts of India and of the states. So any reference to finances or revenues to the central government or state government now has to refer to Article 266 of the Constitution of India. So if you see any older legislation wherein the term central government or state government is utilized, then you need to refer to that particular provision with reference to consolidated fund of the state or the consolidated fund of the India. I hope this is making sense to you. Then let us move further and talk about general rules of construction, that is section 5 to section 13. We are moving into the now second leg of our class. Any question till this particular point before we move on to this? Any question or any clarification specifically you have? We'll be happy to answer. Yeah. Any questions? Any clarifications you have? Sridhar, I could not get your question. If you can elaborate it further. This is with reference to section 4, right? This is with reference to the previous enactment prior to 1950. Anybody else has any other question? You can ask before we move on to the construction part. Yeah. Okay. Previous enactment. Thank you. You can ask any doubts, in the question answer session, Daksh. After the class, I think you have a mechanism of sending an email, or maybe if you are connected on the e-portal, there you can put up the questions and the teachers will be answering it. Right now, if you have any questions, you can feel free to ask. Towards the end of the lecture also, I will be opening it for Q&A session, so you can ask. Okay, let us move further. So general rules of construction, as you can see, section 5 to section 13 talks about it, right? So section 5, we have talks about coming into operation of enactments. This we have already dealt with, right? Commencement. Now we look forward to section 6, that is talking about effect of repeal. What do you mean by repeal? Repeal basically means removing or deleting the law, right? So repeal it is not actually deleting. We say basically that the law is repealed. That means it is not now into force. Okay, so repeal uh, stops it. So let us read the provision, what it says. It says, where this act or any central act or regulation made after the commencement of this act repeals any enactment hitherto made or hereafter to be made, then unless a different intention appears, the repeal shall not. So whenever the act is repealed, any law which is struck down will not do the following things. Okay. So what are the things which it cannot do? First, it cannot revive anything not in force or existing at the time at which the repeal takes effect. So it will not bring something new into force after the repeal. Okay. So if there is something which is non-existent, the repeal of a law cannot bring it. Second, it will not affect the previous operation of any enactment so repealed or anything duly done or suffered thereunder. Like, for example, there was a penalty of 5 lakh rupees for a violation, okay, under the company law. You must have seen that we have decriminalized company law. There were many provisions which have been removed the criminal prosecution or something. But before this repeal, if somebody has done a violation, they have to pay the older fine or provisions. They cannot say that now the law is repealed and hence I am not amenable to the, older violations which I have done. So if the penalty was 5 lakh rupees or before 6th June and a law came on 6th June reducing the penalty to 50,000 rupees, a person who has done an offense prior to 6th June cannot claim that no, now since law is repealed, you just take me. So this clause affect the previous operation will come into force. Then third point, it is saying that affect any right, privilege, obligation or liability acquired, accrued or incurred under any enactment so repealed. So if there is a right anybody has got or a privilege who has got or somebody has incurred a liability or an obligation, that will continue. So by repeal of the law, this will not go away. But new rights will not accrue. There will be nothing new which will be coming into effect, but the older rights which have been acquired by someone will continue to exist. Like, for example, let us take a hypothetical example. There is a CSR contribution of 2%. Now, say, for example, government in further provision reduces this to 1%. So now anybody whose liability was there to contribute 2% has to contribute 2%. They cannot say that no, now it is reduced to 1%, so I will contribute only 1%, right? So this is how the things are. Then it will not affect any penalty, forfeiture or punishment incurred in respect of any offense committed against any enactment so repealed. This I have already given you the example. And fifthly, affect any investigation, legal proceeding or remedy in respect of any such right, privilege, obligation, liability, penalty, forfeiture or punishment as aforesaid, and any such investigation, legal proceeding or remedy may be instituted, continued or enforced, and any such penalty, forfeiture or punishment may be imposed as if repealing act or regulation had not been passed. So these are the 5 important things which you should remember with reference to repeal. So even if the law is repealed, that will not affect these particular points. I hope this provision is clear to you. Any question on this section 6 part? Yeah. Any one of you? Any question on the 6th part? Okay. So let us now. So formally, repeal basically means to officially make a law no longer valid. Okay. So किसी कानून को औपचारिक रूप से रद्द करना is known as repeal. Let us move further. This is situation 1. So can you, I think the answer is already there. but still you can read it. Okay. So this is situation one. Read. Yeah. So you can see here, Urban Sealing Act enabled owners to apply for exemption of land sealing limits. Raj filed an exemption in 2022 and competent authority issued order granting him exemption. Okay. In 2024, the act is repealed and a new law with stricter restriction is enacted. The state government issues a notice saying all previously granted exemptions now stand cancelled due to the repeal. Raj challenges the notice, arguing that he has already acquired a vested right in the old act. Now, under Section 6C, repeal does not affect rights, privileges, obligation, liabilities already accrued. Hence, Raj exemption order is a right accrued before a repeal. In absence of the different intention in the new act, his right survives, and hence the cancellation is invalid in this situation. Now, on this, what you want to say? This is situation 2. What is your answer? Please read the provision. Under the Prevention of Food Adulteration Act, a criminal complaint was filed against M. Mira in 2020, and in 2023 the act was repealed and the Food Safety Act came into force. The trial court closes the case, stating that since the old act has been repealed, the case cannot proceed. The prosecution challenges this order. What would be the decision? Yes. Go ahead. Okay. I think I have got some responses. Trial court is wrong. Okay. I think you are correct. Section 6C protects investigation legal proceedings. The case continues as if the repealing act had not been passed. Trial court's closure order is wrong. Proceeding must continue. Good. All of you have understood this. Let us look at this problem. Got it? Okay. You are saying Arun has to pay the penalty. Let us see. Penalty can't be repealed. Okay. Good, good, good. All of you are making an answer. Okay. Let us see. Yes, penalty can still be imposed, and if repealing act has not been passed, Arun committed the offense before repeal, so liability stands. Very good. So you have understood these provisions. Now let us talk about another example. So another example is you can see here. This is a repeal provisions of IBC. So generally, in whenever a new law comes up, it repeals older laws. Like for example, if you see Competition Act, it repealed MRTP Act. So these laws will always provide for mechanism to deal with the older laws. What happens to the proceedings which were pending in those laws? So if you see here in IBC, when they were repealed, so it said the Presidency Towns Insolvency Act and Provincial Insolvency Act is hereby repealed. By the way, this provision is not yet come into force. Huh? So it says, notwithstanding the repeal under subsection so and so, it is making all these points again. So here, General Clauses Act will not apply, right? Because there is a specific repeal provision. If there is a confusion in interpreting section 243, then people will go to repeal General Clauses Act. But if the law itself provides for mechanism for dealing with the repeal law, then these laws will prevail. Okay. So I hope this, I give you clarity on this. So you can see here, the same things are mentioned, like all proceedings pending will continue, any order, rule, notification which has been made will continue, anything which has been done, purported to be done will be continue, any principal rule of law, established jurisdiction, pleading, etc. will be continuing. The prosecution instituted under the repealed enactment will continue before the court will go ahead with the by the tribunal, and any person appointed to the office under by virtue of any repealed enactment shall continue to hold office until such time as may be prescribed. So this is basically, this repeal provision is there to provide for continuity of the laws. So there is no confusion, there is no chaos because a new law has come up, then how to deal with that. So that is why the legislation always provides for it. If the legislation, central legislation forgets to provide it, then General Clauses Act will apply. Now, there are laws which deals with repeal of act, making textual amendment in act or regulation. So this is an interesting one, 6A. And if you read this, it says where any central act or regulation made after the commencement of this act repeals any enactment by which the text of any central act or regulation was amended by the express omission, insertion, or substitution of any matter, then unless a different intention appears, the repeal shall not affect the continuation of any such amendment made by the enactment so repealed and in operation at the time of such repeal. So it is an interesting situation. What happens is that many a times one law will be referred in another law. So say, for example, Companies Act provision is referred to in SEBI Act, or SEBI Act provision is referred to in Companies Act. Now, if SEBI Act repeals, consequential repeal has not been brought up in Companies Act, right? So this provision says that it will not affect the continuation of that provision under the Companies Act. Say, for example, SEBI Act provision gets repealed. Now you cannot say under the Companies Act, wherein the reference of that SEBI law is there, that since it is repealed, now you cannot apply it, because it will cause inconsistency, because many places laws are referred or co-referenced. So in that situation, this provision 6A gives a leeway. So General Clauses Act says that irrespective of that particular repeal, the provision which has been repealed in the original law will still continue with the, in the referred to act. I can give you more examples on this, but this one we will touch upon in our next class more. So I leave it to you for your own reflection. And tomorrow when I discuss, I will give you more examples on 6A. Now let us look at revival of repealed enactments, that is 7. So it says, in any central act or regulation made after the commencement of this act, it shall be necessary for the purpose of reviving either wholly or partially any enactment, wholly or partially repealed, expressly to state that purpose. So why you are repealing, that you have to say, and if you are partially repealing or wholly repealing, that purpose has to be said. So this section applies also to all central acts made after the 3rd day of January so and so, and regulations made on or after 14th day of January so and so. So see, as I told you, that after the repeal does not struck off the law completely. So say, for example, tomorrow if the law needs to be revived, the government may notify that this law is revived. So law is repealed, then revived. So the law stays there on the statute book, but it can be revived by the court. So this by the legislature, sorry. So this is the provision on revival of repealed enactments. And now let us move further and talk about section 8. And I think this is the last section for the day. It's already 8:26. So I think we can cover this maybe in next class. Any question till this point? Yeah. Any question till this particular point you have, I will be happy to answer. Or any other question which you have till this point. You can ask any question, any doubt, any question you have. Yeah. Let me check the portal as well if there are any questions there. No questions on the portal, but any questions here? So we have dealt with till section 7, and we will move ahead with section 8 in our next class. Uh, but any question till this point? Right. So section 7 basically says that if there is a law which is repealed and you want to revive it, then you have to specifically mention the purpose for which you are reviving that particular law. This is section 7. Section 6A talks about repeal of act, making textual amendment in the act or regulation. Right? So yes, Isha Kumar, you are very right. It is basically like a dictionary for understanding law language. Not law language actually. It is a reference point for interpreting the central legislations. So any central legislation you want to interpret, you will be referring to General Clauses Act. This is how you go ahead with that. Yeah. Move ahead. I am waiting for your questions. Any questions, any clarifications? Last 15-20 minutes I keep for interaction and questions. So we'll be happy to address. Any other question in any other law which you are facing, you can ask now. Not necessarily from the interpretation part of it. Any other law which you feel or any other point which you want me to address, I will be happy to address. Because this General Clauses Act applies to every situation, right? So, yeah. If you don't have any questions, then let us call it a day and you can exit if you don't have any questions. If you have any questions, you can ask me. I am here. If you have any individual questions also, you can ask me anything which is bothering you, you are not able to understand, feel free to ask me. Someone had a question before who wanted to discuss. They can also ask. You can open a mic and also speak if you want to speak. Uh, well, May 2026 paper. What is the question, Sridhar? If you can just elaborate this question a bit, I will be able to help you. Uh, is it required to write sections mandatorily? I think sections, if you remember, then you write, and if you don't remember, then you don't, write wrong sections. That is what I would suggest. Some sections you should remember. Some, even if you don't remember, if you don't recollect, then don't write a wrong section. By practice, you will remember the sections. Like, for example, immovable property. What is the section? We have dealt with so many times today. What is the section for immovable property? Yes, 326. Very good, Isha. So this is how you should remember. And if you are remembering, then you can quote it. If you don't remember, then it is fine. Similarly, it goes with case laws also. So if you remember the case laws, you can write. If you don't remember, you can write the facts of the case laws or situation which is surrounding that case law. Citation, there is no need, but at least the name of the parties you can write that in this case it has happened like that. There is Anil has a question, how General Clauses Act impact Companies Act. General Clauses Act does not impact any act, by the way, Anil. So if there is a interpretation question in Companies Act, which is not getting solved in the Companies Act itself, then General Clauses Act comes into picture. So they will refer to General Clauses Act. But if, say, for example, everything gets covered and interpretation is able to be done in General Clauses in Companies Act itself, there is no need for General Clauses Act. Yes, specific act overrides General Clauses Act. That is very right to say. This is also the principle of interpretation that general laws give way to special laws or special laws overrides the general laws. Okay, then it appears that you people are all clear about the portion which we have studied today, and we will continue with the discussion tomorrow. And read your course material specifically. And if you have any specific questions, I will be more than happy to answer them. Okay, all the best. IT team, now we can close the session.
Recording stopped.